Hello, everyone. Thank you for joining us for this installment of the California Employment News, an informative video and podcast resource offered by the Labor and Employment Group at Weintraub. My name is Meagan Bainbridge, and I'm with Shauna, Correia, my partner today, and we're talking about California's new AI regulations, which take effect on October 1st, 2025. Shauna, can you start us off by providing some background information on these new regulations?
Sure. So, as you know, AI has advanced rapidly throughout the last several years, and employers have, like everybody else, been very eager to utilize it to aid in their human resource processes. For example, AI is currently being used as a tool to automate and optimize such areas as recruitment and hiring, employee development, onboarding, talent management, and workforce analytics. So while this is great, there's been concerns over the rapid growth. And so on June 30th, the California Civil Rights Council has approved some revisions to Title II of the California Code of Regs, which governs administration of California's Civil Rights Department. And these new regulations interpret California's Fair Employment and Housing Act prohibitions against discrimination in recruitment, hiring, promotion, training, and termination of employees, and specifically insert requirements and expectations for employers when they're using AI intelligence, machine learning, algorithms, statistics, or other data processing tools to help facilitate human decision making. So, Megan, can you give us a rundown of what these new regulations actually require employers to do?
Yeah. So the regulations prohibit employers from using automated decision systems, which are defined as any computational process that makes a decision or facilitates a human decision making regarding an employment benefit in a manner that discriminates against applicants or employees based on protected categories as defined under the Fair Employment and Housing Act. As a reminder, these categories include such categories as race, religious creed, religion, sex, ancestry, national origin, medical condition. I think there's about 15 different categories now. But in some, the regulations seek to limit the use of AI tools that rely on unlawful selection criteria or cause a disparate impact on one of those protected characteristics. In the regulations, AI is defined as a machine-based system that infers from the input it receives how to generate outputs, which can include predictions, content recommendations, or decisions. The CRD actually identifies several examples of how employers may use AI in the manner that is implicated by the regulations. Those include such things as using computer based assessments or tests, such as questions, puzzles, games, or other challenges to make predictive assessments about an applicant or an employee that could measure an applicant or employee's skills, dexterity, reaction time, and or other abilities or characteristics that could measure an applicant's or employee's personality traits, aptitude, attitude, or cultural fit, and or screen, evaluate, characterize, or recommend a particular applicant or an employee. It could also include directing job advertisements or other recruiting materials to certain targeted groups. It could include screening resumes for particular terms or patterns. It could include analyzing facial patterns, word choice, or voice on online interviews, and it could include analyzing employee or applicant data acquired from third parties. The regulations make clear that they apply to both the employer and any agent utilized by that employer. So, for instance, if a company uses a third party agency to recruit or screen employees, that would be considered an agent of the company, and the company could actually be held responsible for that agent's improper use of AI. So, Shauna, based on these new regulations, do you have any advice for employers on best practices for compliance?
I sure do. So, a few things. First, it's important for employers to understand whether any AI tools are currently being used by your human resource team or your third party agents that might be covered by these regulations. And if so, it's important to establish a protocol for conducting bias audits to make sure that those tools are being utilized in a proper way that avoids unlawful discrimination or exclusion of applicants based on a protected characteristic. And secondly, if you use any third parties to help manage your workforce, you should ensure that those third parties are using the same sort of anti bias testing protocols for any AI that they're using. And third, once you know whether you're using these tools, then adopt policies that are consistent with the new regulations and make sure to train your HR management team on these policies to ensure compliance. Fourth, I think it's important to notify applicants and employees if AI tools are in use and provide accommodations or human alternatives where that might be required. And finally, it's important for employers to update the record keeping policies to ensure that ADS related data is being stored and maintained for at least 4 years.
Thanks, Shauna. And that's it for now. You can continue to find our video series through the lelawblog.com or on the Weintraub Tobin YouTube channel. You can also catch our podcast wherever you listen to your favorite podcasts. Thank you for joining us today, and we look forward to reconnecting on the next edition of California Employment News. We'll see you then.